I want us to start, we continue from where we reached yesterday, and I think we were doing some revision, and we started with the question from the first cut, or basically from cut 1, and I think we were able to do question number 1, question number 2, question number 3, and also question number 4. What we agreed is that once we meet today, we first of all finish the 2 remaining questions, question 5 and also question number 6. And then from there, we proceed to the mock exam. So we go straight to question number 5. And we start with question number 5A. So what are we told here? We are told in relation to company law, part A, explain the meaning of the term promoter. Part B, we are required to discuss the rules that governs the pre-incorporation contract. And number C, we are required to describe the common law duties of the promoter. So we're going to start with part A of that question. And basically what we are required to do here is to define the promoter. To define who? The promoter. Remember, this is basically something we discussed in topic number 2. And actually we say the promoter in very simple terms. This is the founder of a company. This is the founder of a company. In other terms, we said a promoter is any person who undertakes to form the company with respect to a given project, and basically sets that company as a going what? As a going concern, of which we say that a promoter here does not include any person who is engaged or actually who is involved in the formation of the company in a professional capacity. Meaning that if, for example, we come together, we want to register a company, maybe at a certain point we engage maybe a lawyer to be able to assist us in reforming or basically registering that particular company. That lawyer we have engaged is not a promoter because he has been engaged. We have engaged that particular lawyer in a professional capacity, basically to assist us in registering what? The company. So therefore, a promoter does not include any person who is involved in the formation of the company at a professional what? A capacity. Maybe first of all, we can say that this is a founder of a company, a founder of what? Of the company. And still we can also say that this is any person who undertakes to do what? To form the company, the company with respect to a given project, with respect to a given project, with respect to a given what? A project, and set the company as a going concern, and set the company as a going what? As a going concern, as a going what? A concern. And that is basically the definition, a simple definition of the term who, or basically this particular person who is called the promoter. And I think that simply what was required. Then let's move to part B of the question. And basically what was required in part B is we explain the rules which governs the pre-incorporation contract. So the rules governing what is called the pre-incorporation contract. Pre-incorporation what? Contract. Pre-incorporation contract. Pre-incorporation contract. Pre-incorporation contract. Now, remember in this case, we said that when we talk about the pre-incorporation contract, these are those particular contracts which are entered into on company's behalf before the company is registered or before the company is incorporated with the registrar of companies. In other terms, we refer to this particular contract here as the preliminary what? Contract. Any contract which is entered into by the promoters on behalf of the company, but before the company is registered with the registrar of companies, is a pre-incorporation contract. Essentially, what we say is that this particular contract, as far as the company is concerned, they are null and void because they are contracts which were entered into before the company was registered. And actually, we say that until such time the company is registered with the registrar of companies, the company do not have contractual capacity. The company do not have the ability to enter into any contract. So therefore, that's what we are saying, that this particular contract, as far as the company is concerned, they are actually deemed to be null and void. They are actually deemed to be null and void. This particular contract here do not have any legal implication. If, for example, they are breached, by the end of the day, the company cannot be sued in a court of law. If the third party breaches that contract, the company cannot be able to go to a court of law, take a legal action against that particular third party. And therefore, what we see is that once the promoters have entered into this particular contract on company's behalf, then they will always be held personally liable. So if those particular contracts are breached, the company cannot be held liable, but rather the promoters, we said, are the one to be held liable for the breach of those particular contracts. So what the question was asking, and the rules which governs this particular contract. And I think we discussed on the legal provisions, which are the same with the rules. So number one, we said that this particular contract here, we said number one, they are null and void. They are null and void. Null and what? Null and void. And also unenforceable. They are null and void and unenforceable. Unenforceable. So basically what that means is that this particular contract here do not have any legal implication as far as the company is concerned. So if they are breached, the company cannot be sued, and equally the company cannot go to a court of law and basically take a legal action against the third party for the breach of those contracts. So they are null and void and also unenforceable. Number two, we say that the promoters, the promoters are personally liable. Promoters are personally liable. Are personally liable for the breach of this contract, for the breach of this contract. So mean that if this particular contract are breached, automatically the company cannot be sued in a court of law. So the promoters are the one to be held personally liable for the breach of this contract. But equally in this case, recall, we talked about the various ways through which the promoters can avoid their personal liability. And actually, that is a very, very common question, whereby you can be required to explain various ways in terms of how the promoters, the founders of the company, can avoid being held personally liable for the breach of this particular contract. We talked about so many ways. Number one, we say that we can, or the promoters can enter into this contract in draft form. In draft form means that they will just negotiate those contracts on behalf of the company, but the contract will only be executed. The contract will only be performed once the company is registered. So they just negotiate the contract, but they will also agree with the third party that this is a contract we are negotiating on behalf of the company. The contract will only be executed, will only be performed once the company is registered. Number two, we said that the promoters can also avoid their personal liability by doing what? By basically including a clause in this particular contract that they can only be held liable up to the time the company is registered. Once the company has been registered with the registrar and the contract is breached, then they cannot be held personally liable. On the other hand, we say that the promoters can also do what? Can basically ensure that once the company is registered, the company enter into a new contract to substitute the pre-incorporation contract. So mean that once the company enter into a new contract with the same third party, the pre-incorporation contract between the promoters and the third party will be terminated and replaced by a new contract between the company and the same third party. And actually we say that is basically known as novation. That is known as what? Novation. So we talked about so many ways through which the promoters can actually be able to avoid their personal liability. And actually we said you need to understand, to remember those various ways through which the promoters can avoid their personal liability. Number three, the other rule which governs this particular contract, we say that the company cannot sue the third party. The company cannot sue the third party. The third party in case of the breach. In case of what? In case of the breach. So if the third party breaches this particular contract, the company cannot be able to go to a court of law, take a legal action against that particular third party. Number four, here we said that the company equally, or the third party, that is, the third party cannot sue the company, for the breach. The third party cannot sue the company for the breach. For the breach of what? For the breach of the contract. For the breach of what? Of the contract. So in case this particular contract is the breach, then we are saying that this particular that party cannot be able to do what? Cannot be able to sue the company for the breach of that particular contract. Number five, here we said that the company can do what? Can enter into a new contract. Can enter into a new contract. A contract to substitute to substitute the pre-incorporation contract, contract through a process which is called what? Novation. Through a process called what? Novation. So the company, once registered, can enter into a new contract with the same third party, whereby the pre-incorporation contract would be terminated and basically replaced by a new contract between the company and the same third party. Also, on the other hand, we say that the members of the company cannot ratify. The members of the company cannot ratify this contract, cannot ratify this what? Cannot ratify this contract. So the members of the company, maybe once the company is registered, cannot pass a resolution ratifying this contract. So to ratify the contract means that the members cannot pass a resolution to approve that. In case maybe the contract is breached, the company can be held liable. They can't do that. The members of the company cannot pass a resolution to do what? To ratify this particular what? Contract. So therefore, those are basically some of the legal principles, or basically some of the rules which basically governs this particular contract here, which are known as the pre-incorporation contract. So let's move to the last part of that question, and we are told, describe the common law duties of the promoters. So the question here is asking about part C, common law duties of a promoter. Common law duties of who? Of a promoter. The common law duties of a promoter. Now, remember in this case, what we say is that during the formation of the company, basically we say that the promoters are expected to perform various duties. And actually we say that the duties of the promoters are basically broadly classified into two categories. Number one, we talked about the fiduciary duties, and number two, we talked about the common law duties, the common law duties. So therefore, the duties of the promoters are broadly classified into two. So the question here was asking about the common law duties. But before even we look on those common law duties, recall we said that the fiduciary duties, these are those particular duties which arises out of the fiduciary relationship which exists between the promoters and and basically the promoters and the company to be formed. Remember, in this case, we said the promoters basically are regarded to be the trustees of the company. They are regarded to be the trustees of the company. So therefore, as a result of that fiduciary relationship, there are a number of duties which are expected from these promoters. Which are those duties? Number one, we talked about the duty to account. We say, if, for example, you're a promoter, you're given some amount of money to do a number of things on company's behalf, you must account. You must explain how you spent that particular amount of money, of which you say that accounting basically has to be honest. You must explain how you spent that particular amount of money, if necessary, support that with the necessary receipt. If you paid a number of items, you paid a number of expenses, support that with a relevant document. So then from there, we also talked about the duty of disclosure. In this case, we said that the promoters are expected basically to disclose two things. One is any secret profit. If you make a profit as a promoter, make sure you disclose that. Number two, the promoters are also expected to disclose any personal interest. If, for example, you have some personal interest in a transaction, in a contract you are entering into on company's behalf as a promoter, you need to disclose that to the other promoters. And finally, number three, we talked about the duty to act bona fide. The duty to act bona fide. We say as a promoter, anytime you are doing something on company's behalf, you must do it in the best interest of the company. You must do it in the best interest of what? Of the company, in the best interest of what? Of the company. So therefore, we talked about those three fiduciary duties, the duty to account, the duty of disclosure, and the duty to act what? Bona fide. So let's now look on these common law duties. The common law duties of promoters. The common law duties of the promoters. Common law duties of promoters. Common law duties of who? Of the promoters. Now, when we talk about the common law duties of the promoters, number one, we say that these are the general duties. The general duties of the promoters. So these are what? These are general duties. General duties of who? Of promoters. Of promoters during the formation of what? During the formation of the company. Formation of who? of a company, during the formation of who? Of the company. So, and these duties, we said they include what? We said they include number one, basically to do what? To come up with the company's name, come up with the company's what? Company's name. So it is basically the responsibility of the promoters to come up with a company's name and have it reserved. And have it reserved. And have it reserved. And have it what? Reserved. Now, the other duty of the promoters, the other duty of the promoters, or that is the other general duty. And I've said that these are general duties. These are general duties. So the other general duty of the promoter is basically to register the company, with the registrar of companies. So it is the responsibility of the promoters to do what? To register the company, with the registrar of companies. Number three is that the promoters here do have the responsibility to appoint the first directors of the company, to appoint first directors of the company. Number four, we say that they have a responsibility to do what? To meet, or in other terms, to pay the preliminary expenses. Remember, in this case, we said preliminary expenses. These are those particular expenses which are incurred during the formation of the company. Who should pay those particular expenses? It is the founders of the company. That is the promoters. They have a responsibility to pay those particular expenses. On the other hand, we say they have a responsibility to acquire basically assets or what? Or property for use by the company. By who? By the company. So they have a responsibility to acquire property or asset for use by who? By the company. On the other hand, we say that if the company which is to be registered is a public company, the promoters do have a responsibility to prepare the prospectus. So we cannot talk about to prepare the prospectus. If the company registered, is a public company. If the company to be registered is a public company, the promoters do have that responsibility, basically to do what? To prepare a prospectus. Remember, we say that a prospectus is basically that document, or basically an invitation by the company, inviting the members of the public to do what? To subscribe the shares of the company. The shares of what? Of the company. So that particular prospectus has to be prepared by who? Has to be prepared by the promoters. The promoters have a responsibility of preparing that work, of preparing that particular prospectus. So therefore, those are basically the general duties of who? Of the promoters. And I think that is it. That what was required as far as that question is concerned. That is question number 5. So let's move to the other question, that is question number 6. In question number 6, part A, it reads, identify the different types of meetings that may be held by a public limited company 8 months. So in that case, we are required to identify, in other terms, to do what? To explain different types of meetings which may be held by a public limited company. Remember, you say that once a public limited company has been registered, has actually been formed, that company may convene, in other terms, may hold different types of meetings, different types of what? Different types of meetings. So question number 6, question number 6, part A, types of meetings that may be held, that may be held by who? By a public limited company. So types of meetings that may be held by a public limited company. So I think we talked about 5 types of meetings. 5 types of meetings. Yes, I think we talked about 5 types of meetings. Number 1, we talked about a meeting which is called AGM. The AGM, that is the annual general meeting. The annual general meeting. So remember, I said that the AGM, annual general meeting, this is a meeting which all the public limited companies are required to convene on annual basis. On annual basis, so mean that this meeting here is held on annual basis every year. That a public limited company has to convene this meeting. And actually, we say that private companies are not under any obligation to convene these meetings for their members, to hold these meetings for their members. Number 2, we say that these particular meetings should be held before the end of 6 months. 6 months in the following financial year. In the following financial year, meaning that if, for example, a company is to hold maybe an AGM for 2025, that meeting actually will be held the following financial year 2026, but equally before the end of June. So it is held before the end of the 6 months in the following financial year. And actually, we say that this particular meeting is for it to be convened. The members, we say, must be served with 21 days notice. On the other hand, we say those businesses which are transacted in this meeting, we refer to them as ordinary business. Ordinary business. And I think we were able to look on the various businesses which are transacted during the AGM. So those businesses include what? Number 1, appointing the company's auditor. That is one of the ordinary business, appointing the company's auditor. Number 2 is electing the directors. Number 3 is basically a declaration of payment of dividends. The other one is what is the consideration and the adoption of the audited financial statements. And the other one is about what? Is about consideration and also confirmation of the minutes of the previous AGM. AGM. So therefore, we talked about those as the different types of businesses, ordinary businesses, which are basically transacted during what? During the AGM. During what? The AGM. So the other type of meeting which may be held by this company is something called the EGM, extraordinary general meeting. So extraordinary general meeting, we say that this is any other meeting held other than AGM, and also what? The statutory meeting. The statutory meeting. And actually, we say that this particular meeting here is convened to transact what is called the special business. To transact the special business. When we talk about the special business, we are referring to those particular businesses which cannot be transacted during the AGM. During what? The AGM. And actually, we say that this particular meeting here can be convened either by who? By the court upon application. It can also be convened by the directors. Or it can also be convened by the requisitionist. Remember, in this case, I was able to explain who are the requisitionists. The requisitionists are basically those particular members of the company who had requested the directors to convene this meeting, because we talked about certain number of members who may request the directors of the company to convene this meeting. We say once the directors have been requested to do that, they must convene the meeting within 21 days. If they fail to do that, then those members who had requested the meeting to be held, who are now known as the requisitionists, they can go ahead and basically convene that particular meeting. So the other meeting which can also be convened, in other terms, held by a public company, is something called a class meeting. A class meeting. And actually, we say the class meeting is a meeting of a certain class of who? Of shareholders. A certain class of who? Of shareholders. A certain class of shareholders. For example, in this case, we say that if the company has issued maybe the ordinary shares, and also the preference shares, we said that the company can convene a general meeting of the ordinary shareholders, or the company can convene a general meeting of the preference shareholders. So that particular meeting is known as a class meeting. And actually, we say that that particular meeting is ordinarily held by the company to approve something called the variation of a class rate. Variation of the class what? Of the class rate. When we talk about variation of the class rate, it basically means that this is a meeting which is convened by this company to do what? To approve some changes in relation to some rights affecting a certain class of shareholders. If, for example, maybe the company wants to, the directors are proposing the rate of dividend, the rate of preference dividends, maybe to be reduced from, assuming the company currently is paying 12%, the directors are proposed to reduce that rate of preference dividend, maybe from 12% to 10%. So that one has to be convened, or actually that company would be required to convene a general meeting, not a general meeting per se, but a class meeting of the preference shareholders, whereby the preference shareholders will come in and basically discuss that issue, approve it by a special resolution. So then from there, we also talked about the other meeting which may be held. Let's talk over the board meeting. Let's talk over the board meeting. The board meeting? After we say the board meeting, this is a meeting of the members of the board, is a meeting of the directors of the company. We say that this meeting may be convened anytime. There is no timeline when this meeting should be held. So it may be convened anytime, basically for the director to be able to do what? To transact a number of businesses during the board meeting. And I think also we talked about something called the statutory meeting. I hope you can be able to recall, we said statutory meeting, basically this under the new Companies Act, companies or public companies are not mandated. They do not have any responsibility to convene this meeting. But you said the new Companies Act states that any company which was formed under the repealed Companies Act, under the old Companies Act, it had not convened this particular meeting. You have to go ahead and convene that meeting. But we said under the new Companies Act, Companies Act of 2015, public companies are not under any obligation to do what? To hold that meeting. In other terms, any company which is registered in accordance with the Companies Act of 2015, that company do not have a responsibility to do what? To convene that meeting. So therefore, these are different types of meetings which may be convened. In other terms, which may be held by these public companies. So 8 marks for that. So part B of the question reads, state the rule in 𝗙 versus 𝗎𝗎 and explain the exceptions to the rule. The rule in 𝗙 versus 𝗎𝗎 and the exemptions So this is a rule which we discussed in this topic of meetings, in the topic of meetings. And actually we say that this particular rule here, the rule in 𝗙 versus 𝗎𝗎, basically states that a meeting of a company cannot be duly constituted if attended by one person, even if that person is attending the meeting in more than one capacity. We say you can attend a meeting in more than one capacity. This whereby you're attending a meeting as a member of the company, and also you're attending as a proxy. You are representing another member. Provided it's only one person who is present, that meeting shall be deemed not to be properly constituted. So the rule state that a meeting of a company cannot be duly constituted by one member, even if he or she is attending the meeting in more than one capacity. In more than one capacity. In more than one capacity. Even if that person is attending the meeting in more than one capacity. So attending the meeting in more than one capacity means that he's attending the meeting as a member and also as a representative, as a proxy of another member. So that basically what this rule state. Then from there, we can give the exceptions to the rule. Exceptions to the rule. So first of all, what do you mean by the exceptions to the rule? What do you mean by the exceptions to the rule? The exceptions to the rule, basically, these are the circumstances whereby the meeting of a company can be duly constituted by one person, by one person. So only one person who attended the meeting, but the meeting shall be deemed to be properly constituted. And actually, any resolution which is passed in such a meeting shall be deemed to be valid. Shall be deemed to be what? To be valid. So which are those circumstances? Which are those instances whereby the meeting of a company can be duly constituted by one person? Number one is what we call the creditors meetings. The creditors meeting during the company's liquidation. During the company's liquidation. Now, if you can be able to recall what we said in relation to the topic of company's liquidation, we said whenever a company is being liquidated, meetings of creditors must be convened. One of the main objective of these meetings of creditors is for the creditors to be able to prove their debts, because we say that if, for example, by the time the company is liquidated, you are claiming the company, you're claiming some amount of money from the company as a creditor. There is an amount of money you have not been paid by that company. You have to prove which goods did you supply to that company. Do you have a supporting document? Which services did you provide to the company? Do you have a supporting document? You have to prove that. So therefore, we said there should be a number of creditors meetings. And now, in this case, we said if a company has got a single creditor, then that is the person who is entitled to do what? To attend those particular meetings and do what? And actually to attend those meetings. So therefore, during the company's liquidation, the meeting of creditors can be constituted. A creditors meeting can be constituted by one person where the company has got a single creditor. So number two, we talked about the board meeting. The board meeting of a private company. The board meeting of a private company. Board meeting of a private company. So in this case, we said private companies here are required to have a single director. And therefore, if a private company has got a single director, one director, that is the only person who is entitled to attend the board meeting. And that board meeting, even though attended by one person, the meeting shall be deemed to be properly constituted. Number three, we talked about what we call as the adjourned meeting. Adjourned meeting. So when we talk about adjourned meeting, this is a continuation of a meeting which was postponed due to lack of quorum. Remember, I said that if, for example, a company has convened maybe a general meeting of members, and the meeting do not have a quorum within 1 hour of the appointed time, within 1 hour from the time the meeting was supposed to start, then we say that the meeting will have to be called off. In other terms, the meeting will have to be postponed, or in other terms, it will have to be adjourned. It will have to be discontinued. We said the company should convene, or another meeting will be held next week, the same place, the same time, unless resolved otherwise by who? By the directors. And actually, all the members will be notified that the meeting didn't take place because there was no quorum, and therefore they are expected to attend the following week. So if coming next week, still one member attend, that meeting shall be deemed to be duly constituted, and actually the meeting shall proceed and transact those businesses which were supposed to be transacted by the members. So adjourned meeting. So then we have number four. We have what is called a meeting convened by the registrar of companies. So the registrar of companies can issue an order requiring a company to hold a certain meeting, and equally in this case, the registrar will still order that even if a single person attend the meeting, basically go ahead and basically transact those particular businesses which the registrar of the companies which the registrar has actually ordered to be transacted in such what a meeting. So number 5, we have a meeting convened by a court order. So these are those particular meetings which are convened as a result of an order issued by the court. So in this case, the registrar will equally do what? Will equally not the registrar, rather the court will actually may order as a meeting to be convened and still order that even if that meeting is convened is attended by one person, the meeting should go ahead and transact those businesses which the court has ordered to be what? To be transacted. To be what? To be transacted. To be what? To be transacted. To be what? Transacted. Yes, automatically this one should be the High Court. This one should be the High Court. This one should be what? This one should be the High Court. Yes, I think we can talk about those 5 exemptions, but also remember we have others. We have other what? Other exemptions. We also have other exemptions. So I think maybe we can just talk about the 5. We can talk of the 5, but remember we also have others. Yes. So let's go to the last part of the question, whereby we are required to define what is a special notice. What is a special notice? What is a special notice? Special notice. Special notice. Now, we say that special notice, basically, this is a notice which must be given to the company by its members 28 days before. So the number of days is very important. 28 days before a certain meeting. For example, in this case, we say if the members of the company intend to remove the director or one of the director in the forthcoming AGM and maybe replace him with another director, they want to remove the auditor and replace him, the returning auditor, replace him with another auditor. So they must give the company a special notice. So therefore, this is a notice given to the company by members 28 days before the day of the meeting, 28 days before the meeting, before the meeting, informing the company about their intention to pass a certain resolution. To pass a certain what? Resolution. So this is the notice which is given by the members 28 days before that is given to the company by the members 28 days before the meeting or before the date of the meeting, informing the company about the intention to pass certain what? A resolution. Equally, we can say that this notice is required for what? Or when should this notice be given to the company? When should this notice be given to the company? Number 1 is when the members of the company intend to pass a resolution to do what? To reappoint a director who has attained the retirement what? Age. So this notice is required for a resolution to do what? To reappoint a director. A director who has attained the retirement age. The retirement what? Age. And who can be able to recall? We said a director should retire after attaining the age of how many years? A director should retire after attaining the age of how many years? A director should retire after attaining the age of 70 years. The age of 70 years. The age of 70 years. So we said, assuming a director has attained the age of 70 years, maybe in April here, and maybe our company will be holding its AGM, in June. So basically we said this particular director here who has already attained the retirement age is not supposed to retire in April, but rather this director is supposed to notify the company that he has already attained the age of the retirement age of 70 years, and that director is supposed to retire in the forthcoming AGM. In the forthcoming what? AGM. So automatically, in the notice which will be sent to the members about this AGM, the members will be notified that one of the director has attained the retirement age, and therefore he will be retiring in the forthcoming AGM. But in this case, the members of such a company may be happy with the services or with how that director has served the company, and they wish to reappoint him back despite having attained the age of 70 years. So we said for the members to do that, they must give the company a special notice. They must notify the company 28 days before that AGM that they want to reappoint that director back in the office despite having attained the age of 70 years. That's why we are saying that this notice is required, number one, for a resolution to reappoint a director who has already attained the age of 70 years. Number two, this notice is also required for a resolution to remove the auditor from office, to remove the auditor. Number three is also required for a resolution to remove the director. To remove who? The director. To remove the director. So therefore, this particular notice here is required for those resolutions. Is required for those what? Is required for those resolutions. Yes. So that is it. That basically what is required as far as those questions are concerned. Those questions are concerned. So what I want us to do is maybe just take a short break of 10 minutes, and then we come back. I want us to look on this other paper. That other paper. I've reshared the paper in the class WhatsApp group. So we come back and basically look on some of the questions from that paper. Yes, so we take a short break of 10 minutes. We come back at 1:15.